Author Michael Wolff has claimed in a lawsuit that First Lady Melania Trump threatened to sue him for over $1 billion in damages if he didn't retract Jeffrey Epstein-related statements he made about her. Wolff said in the lawsuit that Melania Trump's threat to sue came over statements he made to the Daily Beast and in 3 videos published on social media, although he added some statements were incomplete phrases and were taken out of context. The lawsuit came on Tuesday, the deadline set by Melania Trump's lawyer for Wolff to retract statements, issue an apology, and pay damages to his client. Through his lawsuit, Wolff announced his intention to use the legal action to put the president and his wife under oath to answer questions about Epstein. Wolff conducted interviews with Epstein before his death. The lawsuit noted that Wolff never said Melania Trump was involved in any of Epstein's crimes. Among the statements the lawsuit said were true were those saying Melania Trump was very involved in Epstein's social circle, where she met her future husband, and that it was fair to question how Melania Trump fits into the Epstein story.
Hey friends, welcome. So, what is happening right now? An authentic FBI interview summary pulled directly from the newly released Epstein files has just landed in the middle of Melania Trump's ongoing lawsuit against journalist Michael Wolff. Not a leak, not speculation. An official document stamped with federal law enforcement insignia, containing words so precise and so damaging that they have sent a shockwave through the courtroom. The narrative Melania spent years and millions constructing just cracked open.
I was notified the other day by Melania Trump's lawyers that they intend to sue me for $1 billion related to some of those statements. I'm not the first here. They have threatened and sued other people for saying similar things. These are called slap suits. They may have really no chance at all of proving defamation, but they sue anyway in order to intimidate you and really to shut down any discussion of the relationship of Melania Trump, Donald Trump, and Jeffrey Epstein.
Let me read you the essence of what that FBI agent typed into the official record. The document states, in language scrubbed clean of ambiguity, that Jeffrey Epstein personally introduced Melania Trump to Donald Trump. Not a business associate, not a vague social crossing, not a party planner whose name has been conveniently inserted into the timeline. Epstein, the same Jeffrey Epstein whose name Melania recently stood behind a White House podium to disown, the same man she looked into the television cameras and claimed she barely recognized, barely knew, and certainly never considered a meaningful figure in her life story. That declaration, delivered with the full theatrical weight of the presidential mansion behind her, has now collided head-on with a government document that contradicts her account in the most clinical, bureaucratic language imaginable. If you have been following this channel through every twist of this saga, you already understand that we do not trade in hysteria. We follow the paper trail, we track the legal maneuvers, we read the filings. And today, every single evidentiary pathway converges on the same destination they have been pointing toward for months, straight into the epicenter of Melania Trump's contested history, and straight toward the question that Michael Wolff has been asking with a bullhorn while ducking billion-dollar legal threats. What exactly is she so determined to protect? And why is she willing to employ aggressive litigation to keep it underground? To grasp the full magnitude of this FBI development, you have to rewind to the genesis of this entire conflict. conflict. Michael Wolff is not some reckless blogger who stumbled into a story too big for his experience. He is the author who exposed the inner workings of the Trump White House with Fire and Fury, a book that sold millions of copies and painted the West Wing as a chaotic operation run by warring factions. Wolff has spent a career penetrating the innermost sanctums of power, and he writes what he finds with a clarity that makes powerful figures deeply uncomfortable. When he pivoted his investigative lens toward Melania Trump and her connections to the Epstein network, he was not peddling gossip harvested from bitter ex-employees. He was applying the same forensic methodology that built his reputation, cultivating sources, securing documentation, asking difficult questions, and reporting exactly what the evidence suggested, regardless of how many legal threats arrived in his mailbox. And let there be no misunderstanding about the scale of those threats. The moment Wolff's reporting began connecting dots that Melania wanted to remain forever disconnected, her legal apparatus responded not with a reasoned rebuttal or a detailed denial, but with the heavy artillery of threatened financial consequences. This is the Melania playbook, refined over years of practice. When a journalist or a media institution gets too close to questions about Epstein, they receive a letter. Not a polite request for a correction, but a cease and desist notice threatening defamation damages so astronomical they would create serious financial strain. The Daily Mail received this treatment and ultimately settled, issuing a public apology to make the legal pressure stop. The Daily Beast faced the same approach. Political commentators and book publishers found themselves targeted by the same legal machinery, all coordinated to send an unmistakable message. Mention Melania and Epstein in the same context and expect significant legal consequences. This is not the conduct of a person who is merely irritated by sloppy reporting. This is the behavioral signature of someone who is deeply concerned about what a full examination might unearth. So, when Wolff published his findings and Melania's legal team predictably dispatched the same threatening correspondence they had used to silence lesser targets, they assumed he would calculate the cost-benefit ratio and quietly retreat. They assumed catastrophically wrong. Wolff did not just set aside the letter, he transformed it into Exhibit A in a legal counteroffensive so audacious it likely caught Melania's lawyers off guard. Wolff sued her first. He marched into New York Supreme Court and filed a declaratory judgment action anchored in the state's anti-SLAPP legislation, those legal statutes engineered precisely to protect journalists and whistleblowers from the weaponized litigation that Melania's team had been deploying. By seizing the initiative and filing first in a jurisdiction with the nation's most robust anti-SLAPP protections, Wolff executed a legal maneuver of considerable strategic elegance. He converted Melania's billion-dollar threat into a judicial proceeding. He transformed her intimidation into evidence, and he informed the First Lady of the United States, in language as formal as a legal notice, that he would not be silenced, he would not be financially pressured into submission, and he would not stop asking questions. What happened next in the legal chess match reveals more about Melania's defensive strategy than any press release ever could. Once Wolff's lawsuit landed, her legal team faced a binary choice. They could engage on the merits, argue that his reporting was factually false, and fight him in open court with evidence. Or they could execute a familiar legal tactic when the facts are problematic: obstruct, delay, and move the battlefield to friendlier terrain. They chose the second option with almost predictable consistency. In the waning days of the previous year, Melania's lawyers approached the federal judiciary and requested that the case be removed from the New York State Court where Wolff had strategically planted it. This maneuver successfully transferred the proceedings to the United States District Court for the Southern District of New York, landing on the docket of a federal judge. This was not a neutral administrative shuffle. This was a calculated move aimed at weakening Wolff's legal protections. New York state anti-SLAPP laws are highly protective of journalists. Federal anti-SLAPP provisions offer considerably less coverage. By shifting the venue, Melania's team deliberately weakened the very legal shield Wolff had raised, and they did it knowing exactly what they were doing. But the procedural maneuvering did not end there. Melania's legal team then advanced an argument so questionable it would be difficult to take seriously if the stakes were not so significant. They claimed Melania had never been properly served with the lawsuit. Let the implications of that claim sink in. The First Lady of the United States, one of the most photographed human beings in the Western Hemisphere, a woman perpetually surrounded by a Secret Service detail, argued to a federal judge that nobody could find her to hand her legal papers. Wolff addressed this with the dry, pointed sarcasm it deserved. He noted that encountering her on a public sidewalk was logistically impossible, and that strolling into the White House to serve process was equally fantastical. The woman who has dispatched legal threats across multiple continents to silence her critics was suddenly, conveniently, a person who could not be located. This service dispute became yet another layer of delay, another procedural hurdle designed to exhaust Wolff's resources and patience before he ever got to ask a single question under oath. And then came the Florida strategy, the most revealing move of all. Not content with merely escaping the New York State anti-SLAPP regime, Melania's legal team pushed aggressively to transfer the entire case down to the Sunshine State, where she and the president maintain their official residence. On the surface, this sounds like a routine venue dispute, but context here is everything. Florida, in this particular legal landscape, carries a very specific implication. It raises the possibility of the case landing before a judge appointed by Donald Trump. Not just any Trump appointee, but the possibility of drawing Judge Aileen Cannon, the very same jurist whose handling of the classified documents prosecution against Trump drew significant criticism from legal observers across the ideological spectrum before she was ultimately removed from that matter. The notion that Melania's legal team was engineering a pathway toward a particular courtroom is not a conspiracy theory. It is a logical reading of a deliberate legal strategy. Wolff himself flagged this publicly, pointing directly at the Trump-appointed judge angle because he understood exactly what the Florida maneuver represented. It was not about geographic convenience. It was about seeking the most favorable adjudicator available. Wolff has contested every aspect of this procedural battlefield. He filed a detailed opposition to the motion to dismiss, while simultaneously moving to remand the entire case back to New York State Court, arguing that the removal to federal jurisdiction was legally defective from the moment it was executed. His position has remained consistent throughout. This case belongs in New York, where the law is built to protect journalists from exactly the kind of legal pressure Melania has deployed. Both motions are now fully briefed and resting on the judge's desk, awaiting a ruling that could reshape the entire architecture of the dispute. The case has survived. It has not been dismissed. It has not been transferred to Florida. It is alive, progressing, and presenting significant risk to the defendant. Then came the moment that changed everything again. Melania Trump walked into the grand foyer of the White House, positioned herself behind a lectern, and delivered a prepared statement to the nation about Jeffrey Epstein. She declared with rehearsed conviction that she was not his victim. She insisted that Epstein did not introduce her to Donald Trump. She characterized her proximity to Epstein as nothing more than the incidental overlap of social calendars, the kind of glancing contact anyone navigating elite circles in that era might have experienced. She characterized her critics as engaged in vicious defamation. She called their reporting lies pure and simple. And then, without acknowledging a single question, without submitting to a single cross-examination, she turned and walked away. Now, if you possess even a rudimentary understanding of how the legal system operates, alarm bells should be ringing. Why would the First Lady of the United States stage a nationally televised press conference about an active federal lawsuit in which she is a named defendant? There exists a foundational legal doctrine called sub judice, which holds that parties to ongoing litigation must not make public declarations designed to prejudice the proceedings or influence the tribunal. The principle is well established. You do not try your case in public when it is actively being litigated before a judge. The courtroom is the appropriate arena, not the White House briefing room. Melania disregarded this doctrine entirely and held the press conference anyway. Wolff's response was immediate, pointed, and significant. He stated that her public remarks directly contradicted much of the evidence. Read that sentence again and absorb its legal weight. This is not a journalist waving his hands and calling her names. This is a plaintiff in an active federal lawsuit, a man who has reviewed the materials and knows what his case file contains, telling the world on the record that the defendant just stood behind a presidential podium and made statements that his evidence contradicts. He specified that her statement contradicts the known timeline and, most significantly, contradicts what Jeffrey Epstein himself directly said about her. This is Wolff signaling with the confidence of someone who believes he holds strong evidence, that he possesses material, whether recordings, documents, witness statements, or other evidence that directly contradicts her public statements. He is not guessing. He is informing the public that the defendant made statements at a White House press conference while an actual court case against her remains pending. But Wolff's analysis of why she held the press conference at all is where this narrative reaches a level of political and legal complexity rarely witnessed in American history. He offered several theories, each more significant than the last. His first and most legally noteworthy theory is that the press conference was an attempt to influence the judge. He noted pointedly and publicly that the judge currently presiding over the case is a Trump appointee. The implication is considerable. Wolff is suggesting that the First Lady of the United States may have used the White House podium to communicate a message to a federal judge with a pending decision in her case. If that theory is accurate, the press conference was not a public relations move. It was an attempt at influencing judicial proceedings dressed in a designer suit. And Wolff connected this directly to the central thesis of his lawsuit, stating that intimidation is precisely what his case against her is about. In this reading, the press conference is not a defense against his claims. It is additional evidence supporting them. His second theory aligns with what crisis communication experts call getting ahead of the story. When you know a damaging piece of information is about to become public, you move first. You seize the narrative, you control the timing, and you attempt to frame the information before it arrives. Wolff suggested that the press conference was precisely this, a preemptive effort indicating that Melania's team knew something significant was coming and were racing to frame it before it became public. If this theory holds, the White House address was not a confident assertion of innocence. It was an urgent effort to shape the narrative in advance. And then the FBI document surfaced, and suddenly Wolff's second theory looked less like speculation and more like accurate prediction. Because the document pulled from those 3 million Epstein files, dated from a federal interview conducted with a woman who served as Epstein's personal assistant, a woman who gave her testimony under a proffer agreement, meaning she was legally obligated to tell the truth under penalty of criminal prosecution, states explicitly in the words of an FBI special agent that Epstein introduced Melania Trump to Donald Trump. Not as hearsay, not as tabloid speculation, as a documented sworn witness account given to federal investigators during an active criminal investigation into one of the most serious sex trafficking operations in modern history. Melania stood behind the White House podium and told the world Epstein did not introduce her. The FBI document says he did. These two statements cannot peacefully coexist. One is the sworn testimony of a cooperating witness facing federal prison if she lied. The other is a scripted statement delivered by a woman who has spent considerable resources pursuing legal action against anyone who dares to challenge her authorized biography. And then there is the Zampoli complication, which drags this story into even more significant territory. Paolo Zampoli, the man who has publicly claimed credit for introducing Melania to Donald Trump, the man now serving as the president's own special envoy for global partnerships, appears in this FBI document in ways that raise serious questions. The document reveals that Zampoli had a romantic relationship with the witness. It reveals that Zampoli attempted to purchase a modeling agency jointly with Jeffrey Epstein, the very same agency that reportedly represented Trump's own daughter when she was a teenager. It reveals that Epstein was visiting Zampoli at that agency during casting calls for young models. The man whose account forms the entire alternative origin story for Melania, the chance encounter, the 1998 party, the "it was Zampoli, not Epstein" narrative, was apparently in business negotiations with Epstein while the agency worked with young models. That is the foundation Melania's entire defense rests upon, and the FBI document has raised serious questions about that foundation. Wolff has not made public declarations of victory. He does not need to. The sequence of events speaks with considerable clarity. Melania held a press conference denying everything. Wolff said her statement contradicted the evidence. The FBI document emerged and directly contradicted her statement. The document simultaneously raised serious questions about the credibility of the man whose account anchors her alternative history. And the lawsuit that Melania's legal team has spent months trying to dismiss, transfer, delay, and neutralize through procedural challenges is still sitting in federal court, alive and advancing through the judicial process. Every motion, every venue dispute, every claim of insufficient service has bought her time, but has not made the underlying evidence disappear. The photographs still circulate. The social connections remain documented. The threatening letters are preserved in the public record. And now the FBI document exists, a government-generated piece of evidence that presents a direct challenge to her public statements. Wolff's third theory about the press conference is perhaps the most striking of all. He suggested with considerable candor that Melania simply has deep frustrations with her husband, that Donald Trump is connected to her current legal difficulties. that his world, his friendships, his extensively documented social connections with Epstein are what brought her into proximity with the most legally sensitive name in recent American jurisprudence. And that now, as Wolff frames it, Trump is doing things that create complications for Melania's carefully constructed public identity. Wolff's reading of the press conference is that it was not a defense of Melania at all. It was a signal to Congress, an implicit suggestion that the man whose associations created this situation deserves scrutiny, that she used the White House podium to quietly, in the coded language of her prepared remarks, suggest that her own husband's connections are worth examining. If Wolff is correct about even a fraction of that interpretation, what occurred at that White House podium was something genuinely remarkable in the context of the American presidency. A sitting First Lady using the most prominent platform available to her to signal that the man occupying the Oval Office deserves exactly the scrutiny she is currently receiving. That transcends ordinary political commentary. It suggests a profound internal tension within the administration itself. We do not yet know how the judge will rule on the competing motions currently before her. We do not know whether the case remains in federal court or is remanded to New York State. We do not know if the Florida transfer strategy will succeed or fail. We do not know the full inventory of evidence Wolff claims to possess. We do not know what other information may still be contained in those millions of unreviewed Epstein files. What we know is this: a journalist refused to be silenced. He sued the First Lady of the United States. She responded by holding a nationally televised press conference about an active federal case, and her opponent immediately declared she contradicted the evidence. Within days, an FBI document surfaced that validated the core questions Wolff has been raising, and the case is still progressing through the judicial machinery, still carrying the potential to require sworn testimony from people who have spent considerable effort ensuring certain questions were never asked in formal legal settings. Melania Trump has constructed her entire public existence on the premise that the story she tells about herself is the only story that matters, and that anyone who tells a different story will pay a significant price. Michael Wolff looked at that price tag and refused to back down. The FBI document now suggests he was correct to do so. And whatever happens next, however this judge's ruling lands, wherever this case ultimately travels, the questions that Melania has spent considerable resources trying to suppress are doing what important questions always do in the end. They are continuing to surface. Stay locked in, because when that judicial decision arrives, this channel will be the first to break down every aspect of what it means.